Hello and welcome to another episode of Earth911's Sustainability in Your Ear, the podcast conversation about accelerating the transition to a sustainable carbon neutral society. I'm your host, Mitch Ratcliffe. Thank you so much for joining the conversation today. We're going to be talking about the law, particularly a lawsuit brought by 16 teenagers in Montana demanding that the right to a clean and healthy environment provided by the state's constitution is being violated. We welcome back the founder of the National Green Amendments Movement, Maya Van Rossum. She was in the courtroom during the testimonial phase of the case in Held versus the state of Montana and heard all 6 days of the testimony, including the state's response to the plaintiffs, which took only a half of the sixth day. It responded to more than 30 hours of the kids' and expert testimony with just a few hours of response. She recently wrote on her blog that, quote, "The Held versus State of Montana litigation is the first time the right to a safe climate is getting a full and fair hearing in the courts with a state green amendment as the key foundation," unquote. And she also said, quote, "In sum, this case is about the equal rights of children to be protected from the extraordinary harms of the climate crisis," unquote. Maya recently contributed an article to Earth911 about another questionable alliance fighting the addition of a green amendment in the state of New Mexico. And we'll turn to that in the second half of the conversation. Here's a little background. 3 states, Montana, Pennsylvania, and New York, have adopted green amendments. And there's little or no evidence that those decisions have slowed the development of green energy services in those states. Despite the apparent agreement that we all need a healthy environment, the clean energy industry and several prominent environmental advocacy groups, including Sierra Club National and the Union of Concerned Scientists, have joined what is called the Interwest Energy Alliance. It's a lobbying group opposing the Green Amendment in New Mexico. The Interwest Energy Alliance's mission is to support laws and regulation which accelerate the deployment of a reliable, cost-effective, and diverse portfolio of renewable energy resources. And yet, they don't want a green amendment in the state of New Mexico. Yet, despite that apparent agreement that we need a clean environment, these organizations are opposing the green amendment in the state of Mexico. We'll learn more about that in a moment. And you can learn more about Maya and the Green Amendments for the Generations movement at forthegenerations.org. For the Generations is all one word, no space, no dash, forthegenerations.org. Welcome back to the show, Maya. How are you doing today?
I'm doing great. Thanks so much for having me.
Well, thank you for joining us. I know you're getting ready for a vacation, and I hope you actually get away this time. But let's start off with just a very basic question here. What's at stake in the case of Held versus the state of Montana? Is it the ability for citizens to hold governments accountable for environmental protections within their state?
You just said it. That's exactly what it is. I mean, the Held v. Montana case is really about whether or not Montana state government can be held accountable to consider the climate crisis in their decision making, and also be held accountable for their proactive prioritization of continuing to extract, transport, and consume dirty fossil fuels, whether they're being consumed in the state or outside of the state. So that's sort of the core of the decision making. But I think what's really at stake is how will the Montana Green Amendment that entitles the people of Montana to a clean and healthful environment, how will that be interpreted in the context of the climate crisis? Will the climate be identified as part of the right to a clean and healthful environment? And assuming yes, will government officials then be held accountable in a meaningful way to ensure that they are addressing the climate crisis, so they are protecting that fundamental right of the people?
So in a way, this is analogous to the debate about whether or not ESG criteria can be used in, for instance, state investment funds, retirement funds. The whole question of whether or not a government can consider the climate crisis in any decision is up in the air right now. And this is the courtroom case that's going to decide this, at least for the state of Montana. How do you see it?
I just want to say it's a little bit different. And the reason why it's different, and to me is so much more meaningful, is because we are not talking about another law, regulation, policy, or program. We are talking about a constitutional entitlement of the people to a clean and healthful environment. And at this point, we only have what I define to be a green amendment an amendment that lifts up environmental rights so they're given the same highest constitutional as other fundamental rights. We only have those rights in Montana, Pennsylvania, and now, as of January 1, 2022, in the state of New York, although we have a lot of other states that I'm working with through the Green Amendment for the Generations Movement to secure this kind of entitlement. But the interpretation in Montana of whether or not those environmental rights include the climate will have ramifications for those other Green Amendment states that currently exist or hopefully will exist in the future, and guide the important value of whether or not the climate has to be specifically mentioned as an environmental right. In many of the proposed states, I encourage people to specifically include the climate. And so a lot of states are, but a number of states aren't. And in our other Green Amendment states, Pennsylvania and New York, like Montana, the climate isn't specifically mentioned. So it really is, to me, something far more important is at stake here. It is the human right of people to a clean, safe, and healthy environment, including a safe climate. And that human right as it is being protected at the constitutional level. You know, what does it mean to have this kind of constitutional right? And that's a little bit different than what does it mean to have another law.
And there really hasn't been any adjudication of this kind of a question before. Is this literally the first time we're talking this through?
Well, it's the first time we're talking it through in the context of climate. We have many cases using the Pennsylvania Green Amendment, the Montana Green Amendment, and the New York Green Amendment in other environmental contexts where the constitutional entitlement has been used to address critical issues involving contaminated water, contaminated air, toxic sites, to address excruciatingly pro-fracking laws, right, that will perpetuate dirty fossil fuels in devastating ways, magnifying their growth and expansion in states, even though fracking is already happening at some level. To what degree can state law be allowed to perpetuate that? So we actually have a lot of really powerful precedent on how constitutional Green Amendment entitlements protect environmental rights. But this is the first time where it's being adjudicated as to whether or not a clean and healthful environment or that kind of terminology should include the climate. And then if it does, how does it impact government decision-making?
Okay, so let's get down to the ground level here a little bit. You talked to the kids, you heard the testimony during the suit. What kinds of communities do they represent, and what kinds of environmental impacts did they call out in their testimony saying, this is what we want to be protected from?
So it was a real diverse set of young people that came forth in this case that are plaintiffs in the case. And so we had some youth, like one might expect, that are very pro-environment and that actually, even in their young years, have demonstrated a life history of advocating for environmental protection and getting good government action to address the climate crisis. But we also had some youth that come from much more conservative backgrounds and where both politically and in terms of their life culture, where we had youth that part of their family life was very focused on hunting, and that the animals that were secured through their hunting, it was not just for recreational enjoyment, although they did express how they appreciated that hunting experience, but the animals that they killed actually provided meat for their families. And that they talked about how they don't buy meat at the store. This is what they eat. But that it was clear that they're I think to me, what shone forth was that the family culture was much more conservative than the other children. We had a lovely young person who was an artist who brought forth some of her beautiful art, including a self-portrait where water was just pouring from her eyes. And as I recall, she characterized that as displaying the despair she felt over the climate. We had indigenous youth talking about their indigenous, Native American culture and how the climate crisis was impacting that. There was the one of the youth was from a ranching family. and, engaged in her whole life as a, her whole young life as a rancher. So we had a woman who was very much, seems to be competitively skiing and a big runner, so it was a real diverse set of youth, but every single one of them was able to talk about how the climate crisis had impacted their health, their safety, their lives with their families and with their community, and how it had psychologically impacted them, and the fear in the present and for the future that it was creating for them. So it was very striking and dramatic.
How would you characterize the kids' feelings about the future? Are they hopeful that the courts can help them? And are they generally hopeful about the future?
So that was one of the things I think about the testimony that was brought forth, was the youth did talk about, again, the despair, the fear, the worry that they experienced as a result of the climate crisis, and really use that kind of terminology, how it had devastated every aspect of their lives. But always the testimony ended with a sentiment of hopefulness, an expression of hope that the court would come out with a determination that would provide them with a remedy and allow them to hold their state government accountable, and really send the message that we have a right to a clean and healthful environment. You have a duty to protect that right and to prioritize that right in every action you take and every decision you make. And that includes addressing the climate crisis.
So Montana was the first to do a Green Amendment back in 1972. And
that's a misnomer. People think that, but the first Green Amendment was in Pennsylvania.
Was it? I'm sorry.
Yeah, and it was in Pennsylvania. And actually, when you look at the language, in my estimation, the most robust language is actually in Pennsylvania. You then have very powerful language in Montana that came the year after. And then in 2022, we got our New York Green Amendment.
Okay, I apologize for the misinformation, but let me ask you this. I mean, almost 50 years later, is Montana living up to the language of its law based on how you heard the testimony in the courtroom? In your opinion, are they doing the right work as a state?
So on this particular issue, on the climate crisis, the answer is no. And that is why the courts are getting involved, because the legislators actually passed legislation that are preventing the regulatory agencies like the Department of Environmental Quality from considering the climate crisis in their decision making. And so being able to have the information necessary to address the climate in the context of the constitutional right of the youth and other Montanans to a clean and healthful environment. And that prohibition on being able to consider the climate crisis complemented by a real prioritization within the state at the legislative level and at the regulatory level to continue to advance the extraction, the transportation, and the consumption of dirty fossil fuels is, coming together and really compounding the climate crisis and all of its devastating impacts, and that state's contribution. So in that context, I would say no. But I think what we see in other contexts with the Montana Green Amendment, I mean, looking at the case law, right? We have had other situations where the Department of Environmental Quality may have fallen down on the job when it came to protecting the environment and natural resources. For example, approving permits for industrial gold mining operations in remote natural areas that would have had devastating consequences for the environment, but also the local economy dependent on a healthy environment. But by contrast, there's another case from a number of years ago where the state itself actually utilized the Montana Green Amendment in order to help protect itself from having to enforce a private deal that would have resulted in some test well drilling for drinking water that could have resulted in the contamination of an entire town's drinking water supply with dangerous toxins. So there, the state was very much on the right side and embracing the Green Amendment protections in its work.
But in that case, there was a very concrete example of a concern, whereas the climate is this abstractions. Let me ask about this. So Dr. Jack Stanford, a water expert, testified about the state of groundwater and surface water in Montana. And it's a dire situation. Can the kids rely on that kind of hard example, the fact that they won't have sufficient water available to them during their lifetime, as the leverage they need to get the court to decide in their favor?
So yes, as you said, Dr. Stanford really talked to water quantity. He talked to water quality. He talked about the algal blooms that are being experienced in waterways. He talked about how the water was quickly warming and what were the ecological ramifications of that. And so he had a lot of really good specific information about how waterways were being impacted by the climate crisis. And that scientific evidence is very helpful in making the point that the climate crisis is impacting the environment and therefore the right of the youth to a clean and healthful environment. But I think on its own, it's powerful and it's compelling. Would it have been able to make the case with just Dr. Stanford alone? Maybe, maybe not. But the beauty of the case that was put forth was there were really over half a dozen experts from many areas of expertise in terms of environment and human health, which all brought forth really powerful information and evidence. And so when you put all of that together with the testimony by the youth about how they've actually been harmed, that's how you got this very powerful case.
So the state had what I would describe as an underwhelming response. How would you characterize their defense of their situation?
So I think underwhelming is an understatement of what a poor job they did. I think first and foremost, the youth case lasted for a full 5 days, and it was robust, and every minute was compelling and powerful with facts and evidence and science. Going into the second week, the state, took less than a day, and they had 3 witnesses. They had 2 expert witnesses going into the case, but midweek of the plaintiffs putting on their case, the state announced that they were withdrawing one of their experts. And I can only imagine it's because as the plaintiffs were having their experts testify, amongst the things that those experts were testifying to was what a bad job the 2 state experts had done in their expert reports. And so it seemed like the state had pulled back one of their experts in a recognition that their expert reports and what they would have to offer was simply not defensible in the face of what the plaintiffs were bringing forth. But they had 2 environmental representatives from the Department of Environmental Quality who essentially said, we can't look at the climate crisis because the state legislators passed a law that said we can't do what the youth want. And therefore, we're in compliance with the law, and, sort of there you have it, which really misunderstands that the Constitution is above the law. Compliance with legislation does not mean compliance with the Constitution. So you had those 2, and they just basically were sort of holding up their hands and saying, well, the state legislature gave us no option, so we're following the law, and there you have it. And then the state called their one expert and basically asked him a set of 5 questions. What is the level of climate changing emissions emitted globally? What is the level of climate changing emissions emitted by Montana? What is the percentage of Montana's climate changing emissions as compared to the global climate changing emissions? What percentage of Montana lands is in federal authority, and what percentage of Montana lands is under indigenous sovereignty? We rest our case. And even with that limited set of questions and answers that you would think would be so purely factual and numeric, even there, the plaintiff's attorneys were really able to take the state expert to task for misinformation, both in their testimony and their expert report, as well as their deposition that had been taken previously.
So if the state can claim it's powerless to enforce its own constitution, what recourse do defendants like these kids have?
So, well, if to go to court, which is what they did, right? And so that is, I mean, that's the regulators were saying that they were powerless to enforce the Constitution because the legislators had prohibited them from doing so.
Moreover, they also characterized it as very much like we're here as individuals, that we can't make a difference because the problem is global. Someone else is doing this to us rather than we're contributing to this problem. That seems to be the underlying challenge here, is that no one wants to take responsibility.
So you are right. That was definitely a line of the defense. So part of the line was a legal argument, which is the legislature is the one that gets the right to decide, to what degree the climate crisis does or does not get addressed. And that ignores that higher authority of the Constitution, which is the people's document, and the people telling government that that's not in fact the case, right? So that's a miss. But you're right. On the other side, the state in their questioning of the experts brought forth by the plaintiffs, as well as their own witnesses, but so much more so responding to the plaintiffs' experts really was saying that, like, the climate, there's so many climate changing emissions in the atmosphere, and no matter what Montana does, it's not going to make a difference for these youth. And there again, that's a mischaracterization and a misunderstanding or misrepresentation of science and reality, but also of what the Constitution requires of state government, which is for state government to ensure that every time it takes action, that its actions are complying with the Constitution, regardless of what is happening in other states or other nations.
This is a really important conversation. I want to take a quick commercial break. We're going to be right back. Hey, extended producer responsibility, change makers, let's unite. Meet me and the Earth911 team in Portland, Oregon this September at the 2023 U.S. Product Stewardship Forum, the nation's only conference dedicated to EPR legislation and best practices. The circular economy is being crafted today, brick by brick, with EPR legislation, and packaging recycling efforts are leading the way. 2022 saw unprecedented momentum, with 18 states considering over 60 EPR bills, and 6 became law. This year in Portland, you'll find exclusive insights from globally recognized EPR experts. The Product Stewardship Institute invites you, the movers who will shake their regional recycling and composting systems with new ideas. Network. Hone your EPR knowledge and form strategic alliances to drive the circular results this world needs. Now is the time for producer responsibility. So join us at the 2023 U.S. Product Stewardship Forum in Portland, Oregon. That happens from September 11th to 14th. Register today at productstewardship.us. Product stewardship is all one word, no space, no dash. Productstewardship.us. Be a part of the solution, because stewardship starts with you. And we are back. Let's continue the discussion with Green Amendments Movement leader Maya Van Rossum. We're talking about Held versus the state of Montana. It's a case involving 16 kids who brought a suit asking the state to enforce its constitutional amendment guaranteeing them a clean environment. So, Maya, after sitting in the courtroom, hearing the testimony, watching the judge, what do you think the ruling will be in Held? And if the kids lose or are found to lack standing, for instance, what's their next step?
So I think the case that was presented was very compelling, and it was very clear on every front. I think that the plain language of the Montana Constitution is very clear and compelling. And I think there's a lot of really powerful legal precedent using Montana's Green Amendment, as well as Pennsylvania and New York's, that can be brought to bear on the mindfulness of this. And I think when you wrap it all and the Judge Seeley, was clearly very intent in her listening to the evidence, and she was very engaged, but in that very intent listening mode, which I thought in and of itself was compelling and demonstrated the importance of what was of the case and the questions at issue, the legal questions and the scientific questions and the moral questions at issue. So to me, there's no question that she's going to come out with a decision. She has to come out with a decision that fines for the plaintiffs. The law, to me, and again, the plain language of the Constitution is very clear. The only way I can see her coming out against it is to somehow try to characterize the climate as something different than the environment. And I just don't see how she gets there with the evidence that was presented.
So obviously the state will then appeal that ruling. This goes to the state Supreme Court next?
I think whoever wins, there's going to be an appeal.
Yeah.
And I think, yes, it's going to ultimately go up the chain, and it's going to ultimately land in the laps of the Montana Supreme Court. And I will say, I want to highlight for people, and truthfully, I'm not even sure the sort of the general political persuasion of the Montana Supreme Court. But what I can tell you is that given the plain language and again, of the Montana Amendment and the clarity of the evidence, I think that they are going to, any right-thinking, clear-headed judge is really going to be obligated to find for the plaintiffs. And I want to highlight for people, people worry so much, and they say, well, the Green Amendment is, if you have that, it's entirely determined by the politics of the moment in the state. And that's really not true. In the Commonwealth of Pennsylvania, where we use the Pennsylvania Green Amendment to defeat a very pro-fracking law passed by a very pro-fracking legislator, signed by a very pro-fracking governor in the Commonwealth of Pennsylvania, there was in place at the Pennsylvania Supreme Court a very conservative set of Supreme Court justices led by one of the most conservative jurists, justices that you could find in our nation. And we got this incredibly compelling decision written by Chief Justice Ronald Castile, that very conservative Chief Justice, where he found for myself as the Delaware Riverkeeper, my Delaware Riverkeeper Network organization that had brought that constitutional environmental argument, he found for us and very clearly laid out the plain language of the Constitution with the clarity of how constitutional law works, really mandated a finding that this pro-fracking law, the provisions that we were challenging, did violate the constitutional Green Amendment of the Commonwealth of Pennsylvania. And so it really is not about politics. It's about the clarity of the language and the clarity of constitutional law. And when you put them together, the decision comes pretty easily, and it comes for the environment and for the people.
Now, absolutely agree with your interpretation of what you just said. But of course, there is a political debate going on, particularly at the national level. We're going to see the Supreme Court in the next session address what's known as the Chevron rule, which essentially allows agencies to define specifics within the law in order to enforce the law. How has watching the Held case changed your thoughts about the importance of enforcement provisions in other state green amendments in the future or in a national level?
I mean, the truth is my conviction is not based on the Held v. Montana case. Almost to the opposite. I have long said that when a climate case is brought in any green amendment state, we will have a positive outcome because of the power of the analyses that I have seen and experienced and secured with green amendments in other states. So it's a little bit of a different way.
Let's say the Supreme Court, the United States Supreme Court, rules to overturn the Chevron rule. Would that be a existential crisis for the environmental movement?
So I think I think that it will have a dramatic impact now, because what Chevron does is it says that the judges have to give deference to the regulatory agencies unless somebody can, come forth and make a demonstration that the determination by the agency was arbitrary or capricious or not supported by substantial evidence. And I will tell you, there have been plenty of times that Chevron deference has supported environmental protection, but there have been plenty of times that Chevron deference has been utilized to uphold very bad environmental decision making. So, it's going to be a dramatic change for the law. It's a little hard sitting here right now and until one sees the outcome to know exactly how it's going to play out. But thinking about the Supreme Court, thinking about the environment, thinking about legislative approaches versus constitutional approaches, we can look at the gun rights case, the New York Rifle Association case, where because there was explicit constitutional language about the right to bear arms, whether you agree exactly with the interpretation or not, there's that explicit right. The Supreme Court was able to, with relative ease, roll back a 100-year-old piece of legislation in the state of New York having to do with the carrying of concealed weapons. By contrast, in the abortion rights case, the Dobbs case, where abortion rights was totally overturned, reproductive rights were ripped away from people, of all, for people with a uterus, essentially, that the failure to have explicit constitutional language protecting the right to an abortion and to access to that kind of critical health care made it very easy for this politically motivated court to wipe away that 50-year-old right. And that's why I raise up that Pennsylvania situation with the conservative court when we're talking about environmental rights, because the clarity of the language is what ultimately, even though that court may not have been naturally inclined towards the anti-fracking outcome that resulted, or pro-environment outcome that resulted, the clarity of the language is what ended up getting you there. So it doesn't do the whole job, but having that clarity of constitutional language really changes things. And, Chevron deference, that's a construction of the court. And it's one reason why a court can sort of, with somewhat ease, if they're politically motivated, wipe it away when they feel like it.
Well, and that political motivation, the political long game that has been played by the right in order to roll back Roe, and for instance, the affirmative action ruling against Harvard and North Carolina, that ended the use of affirmative action in university admissions, demonstrates they know how to play a very long game. That's a 50-year project. How long a game does the Green Amendments movement need to be planning for and bulking up to play?
Yeah. So I was going to say, I think that the Green Amendment movement really demonstrates that we are playing the long game too. We recognize that the legislative approach does not cut it and gives too much power to people with their personal political agendas or profit-making motives who happen to be in politics, and that that under that current system of environmental protection laws, the environmental justice communities writ large, too often are on the losing end of the stick. And so what the Green Amendment movement is, and I started this movement, 10 years ago, but we also have, the Pennsylvania and Montana amendments were passed previous. Now they each have their own history. They didn't immediately start to get used in 1971 and 1972. It took decades until those amendments were used in each of their respective landmark cases to make fundamental change when it came to environmental protection and demonstrate the power of this pathway forward. But nonetheless, the Green Amendment movement is really about using our democracy and using our current system of laws to defend the environment and to defend the people. It is we, the people, taking our power back using this democratic process that, as you have so rightly pointed out, that for decades, the other side has been utilizing against us. So, I think the Green Amendment movement really was I'm proud to say that this is a movement that has been forward-looking for many, many years. And certainly we're not as far along as we want to be or need to be, but we are much further along than if we hadn't been doing anything. And I think that what we are seeing is, at this point, we passed the Green Amendment in New York State. We have Green Amendment proposals advancing in 15 other states, 14 where the language has already been proposed, a 15th where it's about to be. These are states of all political persuasions. Just this morning, I got outreach from 2 other states saying, hey, how do we make this happen in our state? And I say, team up with Green Amendments for the Generations and let's work on it together and make it happen. But so I think that this is a movement that is swiftly sweeping the nation because people know that something stronger is needed and they recognize that this powerful constitutional pathway brings transformational change when you do it.
It's unfortunate that we had to wait until people were feeling the impacts of climate change so desperately that we began to act. So let's turn to your editorial, because this is a situation in New Mexico where the law needs to be put in place in order to set the precedent and start down the path. Your recent editorial in Earth911 talked about the Inter-West Energy Alliance. Tell us about who's behind it and what they're against, or why they're against a constitutional right to a clean and healthy environment in the state of New Mexico.
So New Mexico has been pursuing, the people in New Mexico have been pursuing a New Mexico Green Amendment for about 3 years now, and every year are making powerful progress. And it's a very diverse set of individuals and legislators that are behind it and coming together in support of it and advancing it. But it's a constitutional amendment, so it takes more time to secure. But once you secure it, it's it's unlikely that you'll ever lose it. Inter-West Energy Alliance claims to be a group of clean energy companies, primarily industrial wind projects, and they are asserting and misrepresenting, frankly, that having a constitutional right of the people to a clean, safe, and healthy environment, including, and explicitly New Mexico's proposal includes climate, will somehow be undermining for advancing clean and renewable energy. I think there are 3 important points here. Number one, that's 100% false, that the constitutional entitlement to a clean, safe, and healthy environment, including a safe climate, is actually very powerful value added that will really help advance truly good, clean, renewable energy projects. Right now, not all clean, renewable energy is the same. There are some things that are characterized as a good, clean energy project, and fundamentally they're not. So they're not going to be benefited. But if you truly have a good project, good solar project, wind project, clean energy project, the Green Amendment is really going to help support the advancement of that important solution to help address the climate crisis. So that's number one. So they're just flat out misrepresenting the amendment, and also, saying silly things like courts have no business in determining environmental protection and law and policy. Well, that's absurd. Courts have a business in every area of law, have been long involved very effectively in environmental protection. So that's just like a stupid kind of thing to say, but that's the kind of thing that they're saying. No place for the courts, which is silly. That's number one. Number two, when you actually read their memorandum of opposition, it was written by a firm that, when you speak with anybody in New Mexico that's been working on the environment, will tell you that that's a firm that is traditionally recognized as being as representing fossil fuels. Okay. So one really has to question whether or not this is somehow some sort of front for some sort of fossil fuel. Are some of the clean energy companies that are listed as members of Inter-West Energy Alliance actually fossil fuel companies? It's hard to delve into that. As you know, right, there are many companies that have 2 arms. Yeah. So we have not been able to do that depth of analysis, but I do know that the entity crafting the arguments and really the mischaracterizations that are just fundamentally flawed. In fact, they claim that it's going to result in this onslaught of frivolous litigation against clean energy projects. And the only case that they were able to point to in the Commonwealth of Pennsylvania that involved a clean energy project and Green Amendment language, the Clean Energy Project won. So, and it's well over a decade old. So we don't see Green Amendments being. So they're not showing a lot of evidence this is going to slow the development of clean energy. No, they're not. And when you understand how the law works, right, you understand again, and I'm able to explain very easily how the Green Amendment becomes a powerful positive value added. And that, in fact, if there were frivolous litigation, the Green Amendment would actually be the tool that would help government and industry fend it off and, stop it in its tracks, as opposed to being the source of that kind of, of an inappropriate challenge that would have success.
Mm-hmm.
But so that was like, the second thing was, that pro fossil fuel company. But I think the third thing, which really was a shocker, which I did point out in the op-ed, and I'm so glad that Earth911 printed it. Thank you for that. Was that there are actually some environmental organizations that are part
tell us
of
about that,
IEA.
because it is really surprising to see the names that you tell us who they are.
Yeah. Union of Concerned Scientists and Sierra Club are part of Interwest Energy Alliance. Now, I will say, and I'm not going to mention them because they did the right thing. There are actually two other environmental organizations that are part of IEA, and I reached out to all four organizations, all four of them, and I said, you're an IEA. They're not just doing memos of opposition. Representatives from IEA actually came out in New Mexico, but also then in Nevada, and testified against the advancement of the right to clean water, clean air, a safe climate, and healthy environments, testified against those Green Amendment proposals. Right after, particularly in Nevada, you had a whole slew of environmental justice communities, frontline community members coming up and talking about how the climate crisis and pollution and degradation of their environment was hurting them and their families and their lives, and how critical an environmental justice issue this was, and how the Green Amendment was really part of ending, right, this legacy of systemic environmental racism that we have in the United States of America. And then to hear representatives from IEA come up and very callously, with such callous disregard, misrepresent the importance of people having this kind of basic right to things like clean water, clean air, was really very harmful. But anyway, so these four organizations, I reached out to all of them in the wake of this and expressed what was going on. One of the organizations came out and there's a statement that talks about support of the Green Amendment concept. The other one is working, and we're in conversation, but Union of Concerned Scientists and the Sierra Club National, not
right.
chapters. There are a lot of chapters involved in the Green Amendment movement, and leaders in it. But Sierra Club National both ignored the immense effort of outreach and communication that I undertook to express and explain to them what was going on. And I know I was getting to the right people, and they just refused to respond. And they showed, and to me, silence by acquiescence is the same thing as advocating for something that is fundamentally morally wrong. And the sad thing about Sierra Club, particularly, right, again, we have Green Amendment, we have state Sierra Club chapters involved in the Green Amendment movement, in many of our Green Amendment states nationwide. And so to have Sierra Club National supporting IEA, opposing the Green Amendments that these state chapters are working so hard to advance, that is just a fundamental undermining, and that's just fundamentally wrong.
Well,
go ahead.
I was going to say, when you take the Held case and the anti-Green Amendment movement from IEA in New Mexico, put them side by side, the irony is just strikingly clear. Is the basic principle we need to be thinking about as we apply Green Amendments, whether or not they've been approved or not, that we should use the precautionary principle before we do things to the environment in order to protect people first? How do we prioritize individual rights and the need for business to do business? I think people come first, but we have this dynamic, particularly in the United States. What's your advice?
So first off, that is one of the things that a Green Amendment accomplishes. the precautionary principle, 100%. Government, if it's going to permit or allow industry or emerging contaminants or other things to advance, before it gives its approval, it has to understand with absolute clarity what are going to be the ramifications. Right. And we can see what happens when government does not do that in the arena of per and polyfluoroalkyl chemicals, right? People hearing about the forever chemicals, PFAS chemicals that are now invading people's bodies, drinking water supplies, the flesh of fish and deer that people fish and hunt, right? In for recreation and or consumption. The reason why PFAS was allowed to proliferate in the environment and devastate people's lives so dramatically is because of an absence of law and regulation. The government just went along with it. They didn't look at the ramifications before they allowed this to happen. And we see that across the board. So precautionary principle in order to avoid not just environmental harm, not just human health harm, but economic harm. PFAS is costing companies and communities and individuals dramatic amounts of money to respond to it and to address it and deal with the ramifications. And we see that throughout history. When the environment is allowed to be run amok, it's allowed to be sacrificed for industry profits. It's not just people that suffer, but economic development writ large suffers. So by having a green amendment that ensures that when business operations are allowed to advance, that they have to do so in a way that is best protective of the environment, we avoid economic harms that result from having to respond to that. We actually enhance economic development. There's a lot of job creation that comes from the innovation that results. Preserving the environment has been demonstrated writ large to result in greater economic prosperity. Just look at development projects that are built in a way that is environmentally friendly. Those residential and business operations sell more quickly for more money, and they're often built at lesser costs. So the Green Amendment is not at all, and actually Chief Justice Ronald Castile made this very clear, it is not about a choice between environment and economy. It's about ensuring that economic development happens in a way that protects the environment so we can all benefit from the prosperity that will result on both sides of that coin.
So tell us what states the Green Amendment bills are making progress. Where can we put some effort now to make that happen?
So there are a lot of great states. So I think some places where we have real powerful progress and a lot of extra people power can make the difference. First off, Florida is the one state where the Green Amendment is advancing by citizen petition. And so in Florida, the Green Amendment movement, it's called the Florida Right to Clean Water, needs a lot of people who are willing to help collect signatures or to sign on the dotted line. So if you go to flgreenamendment.org, you'll find the pathway into Florida where if you're from Florida, you can volunteer or sign up in support. The other states are advancing through a legislative path. We are seeing really significant meaningful progress in Delaware, New Jersey, and Maine on the East Coast. Although I'll say in New Jersey, over half of the New Jersey legislature are co-sponsors of the New Jersey Green Amendment. And the only reason why that amendment has not been allowed to advance is because a few people in leadership positions have refused to schedule a hearing. If you can't get a hearing, you can't get a committee vote. Can't get a committee vote, the legislature can't vote in support. So, we need in these states people to speak up and get active in defense. We have real powerful progress in New Mexico. So really want to encourage people to get involved there. Nevada, we have had very early success, but the Nevada legislature sort of only meets every other year. So they're really in a building mode. Oh, on the East Coast, Connecticut's Green Amendment was just proposed and really has made powerful progress in a very short period of time. By the way, for anybody who wants to learn about these, there are two ways to do it. If you go to forthegenerations.org, there's an active states link. Go to active states and you can find all the active states. Or if you are interested in one of the states where I've mentioned, if you do the states letters like NM for New Mexico, nmgreenamendment.org, you'll get to that state's website. Hawaii also is a place. Hawaii has really valuable existing constitutional language that has been used in very meaningful ways. And in fact, is the basis of a youth climate case coming forward that I anticipate is going to be successful too, because of the case that's being made. But that existing what we call trustee language, where the state is the trustee of the government is the trustee of the state's natural resources for the benefit of the community, that will be powerfully strengthened by having a Green Amendment added to the Bill of Rights section of the Constitution. And so there's a lot of interest in Hawaii where they really care about their environment and having this additional language to help bolster other pre-existing language that's already there and again has been used very effectively in certain context. So those are just some. I will say too, it hasn't progressed very far yet, but there's real, our legislative champions really care in the state of Iowa. And I think if you hear about, Michigan, we're anticipating a proposal. The movement in Michigan is really coming together beautifully. The language hasn't been proposed yet. But I think if you listen to all the different, kinds of states, Washington also has a good effort underway, but still at the earlier building stages. But think about the diversity, right? We're talking about Iowa, New Mexico, Florida, Texas has a Green Amendment proposal. Tennessee has a Green Amendment proposal. Texas and Tennessee are right at the beginning stages. But think about the political diversity that I've just sort of laid out there with this Green Amendment movement. It really shows that a Green Amendment and environmental rights really aren't about political agendas. It really is about protecting people, the environment, and future generations.
Well, Maya, that's a great summary. And thank you for sharing so much information about the states, because I think our listeners are looking for opportunities to get involved. We appreciate you spending time with us. Just remind everybody how to find the Green Amendments Movement site.
So it's Green Amendments for the Generations is the name of the organization. And the site is For the Generations, FOR, For the Generations. .org. If you go there, you'll find all the active states. If you didn't hear your state mentioned and you want a Green Amendment movement advancing your state, you'll be able to get in touch through that website. And very literally, I will probably be the person to call you back because I take this very personally. I believe in this movement. And the thing is, it's so simple and so powerful, yet it's pretty easy to get it wrong or to allow the opposition to sort of suggest a change that fundamentally undermines the whole thing. So I really encourage people, you're going to be the leader in your state. I'm not going to be the leader in your state. You're going to be the leader in your state, but let me help you. Let's partner up, work together, and make it happen. So go to forthegenerations.org, get involved, and do know, everybody asks, well, what about a federal Green Amendment? Yes, of course, we need a federal Green Amendment too, but we're starting with the states to build the education, the foundation, the grassroots organizing necessary to position ourselves so that we can pursue a federal Green Amendment in the not too distant future. But if we hop there prematurely, we won't succeed and we'll divert all the critical resources and energy necessary for these state Green Amendments that can provide so much protection and divert it to an effort that's not ready yet. But it will be, I'm hoping, within the next 5 years.
Maya, thanks so much for joining us today.
Thanks for having me.
We've been speaking with Maya Van Rossum, founder of the Green Amendments movement that's building on early efforts in Pennsylvania and Montana, which passed their laws in the 1970s to extend the right to a clean and healthy environment across the country. New York's Green Amendment took effect earlier this year, and if you're in Delaware, New Jersey, or Maine, there is an active legislative debate going on now. Floridians, whose legislature is dominated by anti-regulation politicians, are driving a petition to demand a Green Amendment. And you heard about the potential for progress in New Mexico, Nevada, Connecticut, Hawaii, and other states. So please take a few minutes today to visit forthegenerations.org. For the Generations are all spelled out, no space, no dash, forthegenerations.com, not the numeral for the word. And you can learn more about the movement and the power of these constitutional amendments at the site. You know, there's no sides in this debate when you look at the events on the ground. People across the political spectrum are enduring the longest, hottest heat dome in history this year. Extreme weather touches us all, harming our children's future, threatening the natural resources that citizens of all political persuasions, whether they protect or hunt wildlife, value and want to pass along to their kids and grandchildren. So let's protect the environment. It is our future. And of course, we're going to keep you apprised about those key issues in this debate, including the upcoming decision in Held versus the state of Montana. I hope you'll take a moment to share this podcast or any of the more than 400 interviews we've done on sustainability in your ear. Take a moment to write a review on your favorite podcast platform to help our neighbors, find us. You all, folks, are the amplifiers that spread more ideas so that we can create less waste. So please tell your friends, family, coworkers, and neighbors that you can find us on Apple Podcasts, Spotify, iHeartRadio, Audible, or any of the other fine purveyors of podcast goodness. Thank you, folks, for your support. I'm Mitch Ratcliffe. This is Earth911, and we will be back with another innovator interview soon. In the meantime, take care of yourself. Take care of one another, and let's all take care of this beautiful planet of ours. Have a green day.